within Nabam Rebia.
What's the ground for removal of the speaker?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing. Arrived at his satisfaction that the government headed by Uddhav Thackrey had lost the trust of the House on the basis that, and I quote, he can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test. The governor has no power to recognize a majority faction of a legislature party. And Milord, if your lordships reads paragraph 3 with me for a minute, well, it's very interesting. Seek election directly from the electorate. I don't seek election in my personal capacity. I seek election on the symbol of the party. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip.
Because now we are really in that wrap-up mode of, putting everything together in the mind. So if you could help us do that and formulate what you have to
It's
say,
all let out in the note that I have given.
Excellent.
So, Mullahs, we don't have to really travel anywhere else.
Just formulate it.
That's right. Mullahs, I just wanted to mention one other broad point, Mullahs, before. If your lordships will allow me to respond to your lordship's query a little later, if your lordships permit me to do that. I just wanted to make one other broad point, Mullahs. And that is, if my lords look at Article 180, sub-article 1. So what is it that I am canvassing before your lordships? That there can be no hiatus.
Right.
If there's a deputy speaker against you, we've given notice. The disqualification proceedings don't stop. That's my first, Mullahs, at the outset. I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, Mullahs, is as, Mullahs, the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided, Mullahs, over the House and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the House is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, Mullahs, the person elected as the speaker then, or chairing the House, will decide. There is no committee.
Read with 180.
Yes. There is no committee. So, therefore, Mullahs, all this not dealt with in Nabam Rebia.
What's the ground for removal of the speaker?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, Mullahs, that notice was an ab initio void.
No, but they can always say that, look, we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Chakra and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why, Mullahs, he is allowed to be in the House, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in Nabam. So these are very serious questions. That's another broad point I wanted to make, Mullahs, before I proceed.
Yes.
Anyway, Mullahs, now kindly come to the propositions that I have placed before your lordships. That's the heart of the decision. It's not, Mullahs, that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships, Mullahs. Then, Mullahs, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction that the government headed by Uddhav Thackrey had lost the trust of the House on the basis that, and I quote, majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislature party that they intend to exit from the Mahavikas Aghadi government. That's the heart of the matter, Manas. That's the decision of the governor. That 34 of them have come to me, and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkariya Commission, Maharaj, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test.
All right, let's read ahead so that we'll get your formulation.
Yes. Firstly, it is respectfully submitted that the resolution of 34 members of Shiv Sena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Mahavikas Aghadi government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, Maharaj, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shiv Sena MLAs as demonstrating their intention to exit from the Mahavikas Aghadi government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shiv Sena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law. Paragraph 3 of the 10th schedule, as it stood prior to its deletion, stipulated that where a member makes a claim that he and any other members of his legislative party constitute a group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party, the same would constitute a valid defense in a disqualification petition filed against such members under paragraph 2 of the 10th schedule. Well, my lord asked me this, a question related to this. Well, paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and give that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And Milad, if your lordships reads paragraph 3 with me for a minute, well, it's very interesting. Would you have it?
Yes.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in the original political party. Any such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 on the ground that he has voluntarily given up or that he has voted or abstained from voting. From the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of para 2, and to be his original political party for the purpose of this paragraph. So, what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework. because he is not the party. Because the party is registered, Malad, under Section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And Malad, the Constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the Speaker is only the members of the legislature belonging to that political party. So you can't say, I am the party. So that proposition is unfounded in constitutional law. So I'll read. And Malad, your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioners' written submissions, 160 to 163. Malad, your lordship have it. I've given the page so that it's easy, Malad. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? Malad, there's a constitutional basis for that also. I tell you lordships why. Malad, when I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohon says you can't go against it.